Welcome back, everyone, to Wolfstorf Rosenthal's continuing H-1B Toolkit for Employers webinar series. Today, we're talking about H-1B request for evidence. Before we get started, quick legal disclaimer. This does not constitute legal advice and is for informational purposes only. For legal opinions, please schedule a consultation with one of our attorneys. Speaking of attorneys, we have two great presenters for you here today. Troy Wilson is a senior associate with our firm, and since joining the team in 2017, he has assisted in a variety of companies with financial services, financial technology, and other highly regulated sectors in obtaining positive results in both immigrant and non-immigrant processes. Colin Gallagher, an associate with the team in our LA office, specializes in perm, non-immigrant petitions for skilled workers, executive managers, and people of extraordinary ability in the arts, sciences, and business. They have a great presentation ready for you guys. I'll let Colin take it from here.
Thanks, James. So the purpose of our webinar today is to discuss requests for evidence in the H-1B context. Today, we will cover the following 4 topics: arbitrary requests for evidence, specialty occupation requests for evidence, other common issues found in H-1B requests for evidence, and helpful tips for responding to a request for evidence. One of the most disheartening aspects about receiving a request for evidence from USCIS is reading through the RFE and finding that it is arbitrary in nature. There are 2 types of arbitrary requests for evidence that we see. The first occurs when USCIS arbitrarily disregards the evidence that has been provided. If you've received the RFE from USCIS, you've read the following line: "The evidence you submitted is insufficient." While reading this line can be concerning, oftentimes the statement is not actually true. Oftentimes, the petitioner has provided sufficient evidence, but the evidence has been disregarded by USCIS. You will even see instances in which USCIS will list the evidence that has been provided by the petitioner, claim that that evidence is insufficient, and then proceed to request the exact evidence that the petitioner has provided in which USCIS listed in the RFE. The second type of arbitrary request for evidence occurs when USCIS arbitrarily disregards the applicable standard of proof. It is important to remember that USCIS is required to apply the preponderance of the evidence standard of proof. Preponderance of the evidence requires that the petitioner prove that it is more likely than not that the matter asserted is true. More likely than not refers to a 51% chance that the matter asserted is true. Thus, you do not have to prove your case beyond a reasonable doubt, and you do not have to prove your case with 100% certainty. In fact, even if a USCIS officer has a reasonable doubt about your case, the officer is required to approve your case if you have proven by a preponderance of the evidence that, for example, a certain beneficiary is eligible for the classification sought. Now, while it is disheartening and concerning to learn that USCIS can disregard evidence that has been provided and disregard the appropriate standard of proof, rest assured that our team is well equipped to respond to these requests for evidence in such a way as to hold USCIS accountable in both acknowledging the evidence that has been provided and applying the appropriate standard of proof. For example, we often include language in our responses to RFEs that a federal judge deciding this case based on the preponderance of the evidence standard would hold, for example, that a certain beneficiary is eligible for the classification sought. So what are the requirements for a specialty occupation? According to the Code of Federal Regulations, to qualify as a specialty occupation, the position must satisfy one of the following criteria. First, that a baccalaureate or higher degree, or its equivalent, is normally the minimum requirement for entry into the particular position. Second, that the degree requirement is common to the industry in parallel positions among similar organizations, or in the alternative, the employer may prove that its particular position is so complex or unique that it can only be performed by an individual with a degree. Third, the employer can prove that the employer normally requires a baccalaureate degree or its equivalent for the position. Or fourth, that the nature of the specific duties is so specialized and complex that the knowledge required to perform these duties is usually associated with the attainment of a baccalaureate or higher degree. One thing we wanted to highlight in reference to this code section is that you are only required to prove one of these prongs. There are varying approaches to this. Some attorneys will attempt to prove all 4 prongs and see which argument sticks. Others will focus on the strongest prong and make the best possible argument for that prong. Let's look at these prongs individually and go through 1 or 2 ways that each prong can be satisfied. For the first prong, that a baccalaureate or higher degree or its equivalent is normally the minimum requirement for entry into the particular position, USCIS will refer to the Occupational Outlook Handbook, or the OOH, as an authoritative resource on the educational requirements for a specific position. When looking at an OOH entry for a certain position, you want to look at the section which outlines the typical entry-level education. If you see that the typical entry-level education is a bachelor's degree in a specific specialty, then you can make an argument that a bachelor's degree is normally the minimum requirement for entry into the particular position, because normal and typical are synonymous terms. For the second prong, that the degree requirement is common to the industry in parallel positions among similar organizations, or in the alternative, that an employer may show that its particular position is so complex or unique that it can only be performed by an individual with a degree, our firm likes to include industry job postings or industry letters to help satisfy this criteria. When talking about industry job postings, the posting should be for similar positions, ideally with identical job titles at similar companies. Please note, when we say similar companies, we mean similarly sized companies in the same industry. When providing industry letters, the letter should come from upper-level management at similar companies in the same industry. The reason these letters should come from upper-level management is we want to be sure that the individual signing the letter has the authority to attest to the educational requirements for a given position. With that, I'll hand it over to my colleague Troy, who will finish the remaining discussion topics.
Now, Colin just discussed some of those factors of prongs that are external to your organization that can be used to demonstrate that a position qualifies as a specialty occupation. We're going to switch gears now and discuss some factors that are internal to your organization that can also be used to demonstrate that the position qualifies as a specialty occupation. One of the first ways that an employer can demonstrate a specialty occupation is by providing documentation that it normally requires a baccalaureate degree or its equivalent for the position in question. This is typically done by providing USCIS with previous job postings or previous requisitions for identical or similar positions within the organization. It is important that this documentation support the assertion and establish a hiring pattern that a specific specialty degree is required for the role. Additionally, the employer can seek to provide a letter that outlines the number of past hires in the beneficiary's position with the beneficiary's degree. Again, the idea is that we need to establish a hiring pattern that supports the assertions in our H-1B petition. More often than not, however, a successful RFE response will demonstrate that the nature of the specific duties of the role is so specialized and complex that the knowledge required to perform those duties is usually associated with the attainment of a baccalaureate degree or higher. To do this, we should be providing USCIS with a more detailed job description that includes an estimated percentage of the time spent on each duty. We should then clearly and explicitly link each of these duties to education or experience required for the role. While arbitrary RFEs or specialty occupation RFEs are often common, they are not the only potential request for evidence that USCIS may issue in the H-1B context. There are additional RFEs common in situations where an employer is placing an employee at a third party or client worksite. This includes a request for evidence where USCIS is seeking additional documentation to demonstrate that the employer-employee relationship existed at the time of filing. Additionally, USCIS may require an employer to submit additional documentation that supports that there is enough work at that offsite work location for the duration of the petition. Sometimes USCIS may request evidence related to the beneficiary, and this may often include evidence that demonstrates that the individual has continually maintained lawful status here in the US. Another common RFE in the context of maybe a startup or a smaller company is that USCIS may require that company to demonstrate that it has sufficient specialty occupation work to cover the duration of the petition. Some helpful tips when responding to requests for evidence in any context, especially the H-1B, is to remind USCIS respectfully of the evidence included in the initial petition. Additionally, we should support all assertions with additional documentary evidence. And we should always remember our audience. USCIS is not in the business of hiring technical experts to review each and every petition. So we should clearly and concisely respond to the RFE with the evidence requested. Thank you for joining us for today's webinar on H-1B request for evidence. Should you have questions or need for legal advice, please contact one of our Wolfsdorf attorneys.